Just moving on from there, then, in terms of how the law is currently set out, what do you see as the biggest issues that we face with the current surrogacy laws that we have?
I think the biggest thing, well, it's very difficult to identify one particular issue. I think there's a general acceptance or acknowledgement in those who specialize in this area of work that the law as it stands currently isn't fit for purpose. And in fact, the Law Commission have been looking at surrogacy for the last 4 or 5 years, and one of the law commissioners for England and Wales and the Law Commissioner for Scotland, they have said essentially that it's not fit for purpose, and it was done over 30 years ago. And it doesn't reflect modern times. One of the things which I think intended parents find difficult is the lack of certainty under English law, and the current legal framework is that the birth mother is always the mother. And so that's often why people travel to other jurisdictions, because they feel there's more certainty that the child will be placed in their care. And they are ambivalent about the current legal framework in this jurisdiction, where it's not guaranteed that they'll be recognised as parents. So in the extreme circumstances where a surrogate might refuse to hand over a child to the intended parents, they are concerned that they will never be recognised as legal parents. And indeed, there have been cases, for example, where the surrogate, even though the child has been placed with the intended parents, the surrogate has refused to give consent to a parental order. And what that means is that they won't be recognised as legal parents unless they try to adopt the child. And so at the moment, you can't dispense with consent from a surrogate who's unwilling to give consent and can be found. So that can sometimes pose a difficulty. I think in relation to, some of the things the Law Commission has proposed, for example, is that if you meet certain criteria and you're on a particular pathway, at birth, the intended parents can be recognised as the parents and have a birth certificate issued at birth that says they're the parents. And one of the things that's often observed by surrogates, and I was at a conference recently where this was said by surrogates, by English surrogates, is that they find it just utterly peculiar and quite uncomfortable that at birth they have to put their names on the child's birth certificate, even though it's not their child. And they say that they readily say that it's not my child. I gestated the child. It's not my child. I don't want to have be on that birth certificate. And also, there's a legal implication to the surrogate too, because what happens if the intended parents change their minds? Then you've got a surrogate who's legally responsible for this child. So I think those kind of things, creating certainty as early as possible, are probably quite sensible. There is at the moment a jurisdictional requirement that says it has to be domicile. One of the suggestions made by the Law Commission, and we won't know until the spring of 2023, when the Law Commission is due to publish its final report with a draft bill for Parliament. But one of the proposals has been that the jurisdiction requirement should be either domicile or habitual residence. And of course, Habres is obviously a lot easier to establish than domicile. And so that would it would make it more inclusive. It would broaden the tent to allow more people to qualify for it. And of course, the key thing is with these orders is that it's better that children are subject to these orders than not. So why not broaden the availability of it? Another issue that often arises is in relation to, obviously I've discussed the time delay, that people are applying late. I think one of the proposals might be to say that there should be no bar on when you can apply, which would probably make sense. And I suppose the other issue is in relation to where you have got issues of double donor embryos. There's a suggestion that there might be a case where there's a need for medical necessity, i.e. both parents are infertile, that they could use double donor situations and still qualify for it. I think it's saying that it should only be in this jurisdiction. But then, of course, that brings up the whole question of, well, how do you define medical necessity? Because
that's a difficult one, I think, and it's really quite interesting because I suppose, does Article 8 of the ECHR offer any assistance to people in those circumstances with their right to family life? And I know you mentioned with the Child Arrangements Order Plus, I mean, even where you've got biological parents, the court will retain the power to terminate parental responsibility in some rare circumstances. Would that ever be something that the court consider where you've got a situation with a double gamete donor?
It's really difficult. I mean, I suppose where you've got a double gamete donor, it does seem to me to be, I mean, that in those circumstances, it depends how it's drafted, but in those circumstances, you might have a situation where actually it's really unclear who the legal parent is if it's double donor. I mean, I thought what was interesting I learned recently was that I think it might be New Zealand, because one of the things that occurs to me about medical necessity is that you could easily have a situation where you have two 70-year-olds saying, well, we're both infertile, but let's have a child. So what's stopping them? But one of the things that says, that is in, I think it's in New Zealand, I might be wrong, but certainly the provision in another jurisdiction was that to apply for a parental order under the medical necessity kind of element, both of the applicants have to be expected to be able to live to the child to be 18. Now, that's obviously very difficult to police because, you know, how do you formulate that? But obviously there's a thinking there that, you know, where do you draw the line? You know, do you allow two 80-year-olds who might be very wealthy and might have a particular reason why they want to have a child to make sure that their wealth goes to the child? Why don't they do that? So it can get quite murky. But I think the law commissioners have been extremely careful and have canvassed wide and varying views. And so I think because it's such a topic that has so many different aspects to it, I would have thought it's going to be relatively conservative, but I think it's going in the right direction in terms of making it more accessible and making it more up to date.
It's good to hear they're working on it at least, and it's on the radar and on the agenda.
Yeah, definitely. It's definitely on the agenda.
Be interesting to know from you how you think those pitfalls could be prevented or avoided. I mean, I know you've already spoken about taking advice at an early stage. What else could intended parents do to protect their position?
I think actually, Vanessa, you basically just said what I was going to say, because I can't emphasize it enough that the legal advice is so key. Because one of the problems that I often see, and it's not to do with the statutory criteria, is that sometimes intended parents go to jurisdictions, particularly if they go to low-income jurisdictions where there is little to no regulation of surrogacy. In those jurisdictions, the relationship between the surrogate and the intended parent is often at arm's length relation. And so they have no real understanding of who this woman is, where she lives, anything about her background. And then that becomes problematic when you need to obtain her consent. What language does she speak? Does she have any children? Is she married? And then throw into that a global pandemic. And then throw into that an earthquake, and then throw into that all these other kind of world events, and then throw into that a war. So these are all things that then make it complicated. And, you know, a war in Ukraine was it reasonably foreseeable? Possibly. I mean, Russia's been a problematic aggressor for some time in that part of the world. But that has made, you know, there've been a number of Ukrainian cases that have been very difficult in light of the war for understandable reasons. And there have been a number of cases during the peak of the pandemic that have been particularly difficult. And if you go to a jurisdiction where it's at arm's length relationship, then getting all these details, getting a notarized form that says she consents to it, that's been translated, getting her served, making sure she has notice of the next hearing, making sure she has all of the papers that are translated, become much more harder if you go to those jurisdictions. And one of the problems is that often people go to low-income jurisdictions because it's seen as it's cheaper, and often it is, but then sometimes it can be problematic down the line. Of course, we can't tell clients what to do, but we can just set out that these are some of the problems that you might entail, and it does make things difficult. And you need to do your due diligence, is what I would say, to make sure you're doing it. You're going to be in a position where you're recognised as a legal parent. I mean, you know, intending parents go on very difficult journeys. It's often easier for same-sex male couples because they can't have a child naturally, as it were. But if, you know, opposite sex couples have often had very traumatic experiences of miscarriage, IVF, adoption, and so they come to surrogacy and they may have their judgment clouded somewhat because they're just looking at getting to the end point. And that's perhaps understandable. I have every sympathy for that. But I think that has to be borne in mind, that you've got to do due diligence because you're bringing a child into the world and you want to make sure that you're, after all you've gone through, that you're recognised as a legal parent. So advice. And it's been repeated in a number of judgments saying that, you know, you need to, you know, you should do your homework before you start this. So that's what I'd say about pitfalls. I mean, that's kind of a global kind of pitfall point.
No, thank you very much for that. I think that's very helpful. And it's also very helpful that you've set out the difference in different jurisdictions, because one of the things that we see constantly is the fact that people travel abroad and don't really realize the impact of that. And something that you flagged up about not knowing the history of the surrogate, for example, you know, medical history or where they are. And I can imagine how traumatic that would be if you're then trying to get that consent that you can't get to be able to bring the baby to the UK. That being said, then, do you feel that sort of what the Law Commission is trying to propose and the bill that they're going to be bringing forward next year to put before Parliament, do you think that those changes that they're suggesting, that they will have an impact and that it would put us in a better position, you know, in terms of the legal framework on surrogacy?
Well, I think the problem is that as we talk, we're kind of talking in a vacuum because I don't actually know what we're going to say. And then until we get the bill, we'll have more of a flavour. But I think one of the ambitions of the Law Commission has been to address what might have been characterised as surrogacy tourism. And so I think what the aim or ambition has been that there are fewer people going abroad or feel that they are obliged to go abroad to enter into surrogacy arrangements. And so I think creating more legal certainty probably will have a impact, that would allow people to have that assurance that they'll be on the birth certificate. So the problem is that you only really bear out how successful those proposals are when you look at it once you've got a new act. And if a bill is proposed in spring 2023, well, goodness me, I don't know when the act would come, because we all know that Parliament can be quite up and down. It certainly has been over the last 5 years. So, and I don't know, it doesn't, I mean, although it probably has I know it does, it has cross-party support because it affects everybody from every walk of life. So politicians would be stupid to ignore it. But that being said, it might not be seen as that much of a priority to kind of push it through Parliament. But I think, as I say, I think it does address that point, that giving certainty will mean there's probably fewer people going abroad. But ultimately, people have the right to have choice, don't they? So they can choose what they want to do. But having choice also means having options, isn't it? So some people feel they're not forced, but they've got no other option other than to go abroad. But if they're not in a particular bracket where they can afford to do the California route, which might cost a lot of money, they might end up going to a low-income country, for example. And that's where I suppose the Law Commission may wish to try and reduce that, so that there's not a need to do that, because they can do it in this jurisdiction altruistically.
And I suppose it's probably better off addressed because, you know, I anticipate that, you know, intended parents may often encounter difficulties immigration-wise in terms of bringing the children back to the UK and getting the surrogates' consent to that process as well.
Yes, and you hit the nail on the head, Vanessa. That can be extremely problematic. I mean, one of the things that happens, for example, again, I use the American example because it's very easy, is that anyone born on US soil under, I forget which amendment, if it's the 13th Amendment or the 14th Amendment, is automatically afforded US citizenship. So they're given a US passport. It's possible also to obtain a British passport before a parental order is made. It's much easier if one of the genetic parents is British, because then, I'm no immigration lawyer, but that then means they're British by descent. So you can obtain a British passport. But for example, with the war in Ukraine, that has created so many tensions and so many difficulties, because people have been displaced, they've ended up having a child born. You know, if you've had a surrogate who has been pregnant during the war and was due to deliver at any point between, you know, when the war started in February to now, and they've been displaced to a different jurisdiction, so a neighbouring country, Poland, Romania, Hungary, Moldova, wherever, those jurisdictions might not recognise surrogacy. So the intention had been the child would be born in Ukraine and the intended parents would be on a birth certificate in Ukraine. But if the child's born in one of those countries where they don't do surrogacy, then what happens? And then that then might create another problem. But the war in Ukraine has been a unique one because there's been a lot of pressure that was applied at the very beginning. A lot of good pressure was applied, and the Home Secretary at the time was very responsive to it, and the Home Office was very responsive to it, to create a good pathway to kind of obtain the relevant emergency papers to get people back here, including surrogates, in fact. But you know, those things can get complicated, and then you have the factor of COVID. I've seen cases where the intended parents have been, one's been here, one's been in the country where the child was born, and they've been apart for months, and they're not been able to get papers. It's just, so it can be a bit of a nightmare, and so people have to take these things into consideration and think about the unforeseeable, you know.
Thank you so much, Andrew. We're really, really grateful that you've given your time. This has been very insightful, albeit, you know, we've tried to compact it as much as we can. We're going to link the Law Commission's report in on the webinar once it's published. Also, I was going to jump on your book. Have you got a copy with you, please? Because we always do that. Because Andrew has written a book on surrogacy, which he's trying to find. But again, we'll put the link to the book on the webinar so that you can get yourself a copy if you want to know more about this area of law. I think, as he said, is something that all of us need to be aware of, because you never know when, you know, it might just come across our desk from any of our clients. But we will put the link as well on the webinar, so for people who want to get a copy of the book. But thank you so much, Andrew, for your time today. We're really grateful. And hopefully we'll have you on again to speak to us once we've had the Law Commission's report come out and the bill has gone through the Parliament next spring. And then we can pick up from there as to where we are with it and what you think will happen. And hopefully it will actually lead to changes in the law sooner rather than later.
Thank you for having me.
Thank you. From Vanessa and I, we're really grateful, and we hope that you all enjoy this webinar, and we will be back with another installment soon again. Thank you.